Well, thank you very much, Professor Hunter. It really is wonderful to be here in King's College and to have you co-host this event. This is a special occasion because I want you all to know this is a truly exceptional book. It is quite extraordinary in the remit, the way in which it deals with comparative law, the way in which it indicates ways in which law can be improved, and the importance of freedom of speech in our world and how it might be protected and some of the failures in protection in international law. I'm going to welcome you to this incredibly distinguished panel, and you will also hear from many of the distinguished people who are here in this audience. But I welcome all of you, and I hope that you find this evening enjoyable and that you will buy this incredible book. And I want you to know that it is for sale at the reduced price of 30% off. Because you will end up desperately wanting to buy it at some later stage. Buy it tonight at this special price. There will be another advert for the book later in the occasion. Now, let me introduce you to Lord Neuberger. Lord Neuberger is one of the, of course, the authors of this book, and he's a very precious part of the media freedom debate and commitment of the high-level legal panel. He is the chair. He, as you know, was the president of the UK Supreme Court from 2012 to 2017, and it was a great regret to many of us that he had to step down when still such a young man. And he has actually decided cases involving some of the most significant human rights and constitutional law issues that there have been in this country, and has written and spoken extensively on free speech and privacy issues. He has been a judge in other constituencies, and he is the president of the British Institute of International Comparative Law. And as I said, he's the chair of the high-level legal panel of legal experts on media freedom. And that's an independent advisory body composed of leading experts in international law, established at the request of the International Media Freedom Coalition. And so it really is a global entity, and it has the most expert lawyers on it. And I'm glad to tell you that I have a number of them here with me tonight. But I'm going to also introduce the rest of the panel before we get started. Amal, the co-author, Amal Clooney, the co-author of this incredible book, is a barrister who spent the last 2 decades defending victims of injustice around the world. She represents clients before international courts, including the International Criminal Court, the International Court of Justice, the European Court of Human Rights, and domestic courts in the United Kingdom and the United States. And if I'm ever in trouble, she's the woman that I'm going to have representing me. She has secured victories in landmark human rights cases. She's won numerous awards for her work in freeing detained journalists around the globe. And she's an adjunct professor at Columbia Law School. She, with David, they have co-authored this book, but she also co-authored The Right to a Fair Trial in International Law, which was an award-winning book. It was received the top publishing award of the American Society of International Law back in 2022, a couple of years ago, and that she received along with Philippa Webb, who I'm going to introduce you to shortly as well. As many of you will know, she is married to George Clooney, and together they co-founded the Clooney Foundation for Justice. It really is an organisation that does incredible work. The Clooney Foundation provides free legal support to victims of human rights abuses in over 40 countries around the world. Incredible trial watching programme, and a really very important work in changing people's lives. Philippa Webb. Philippa, wave to the audience, because of course you know half of them. Philippa is a professor of public international law at King's College London. She's the director of the Centre for International Governance and Dispute Resolution, and she really is the queen of dispute resolution. She is currently a visiting fellow at Exeter College and is the academic visitor on the Faculty of Law at the University of Oxford. She is also a barrister at 20 Essex and is appointed to the Attorney General's Public International Law Panel, and she's one of their counsel. And she has served as the Special Assistant and Legal Officer to Judge Rosalind Higgins, who was the great judge who was President of the International Court of Justice, and at that time Pippa worked for her and to great acclaim. Her publications are many, and I can't give you them all because we would be here all night, but she is a remarkable lawyer and recognised as one of the great scholars in this field. Dario Milo, who's sitting here to my right, has practiced in the area of media law at a leading law firm in South Africa for almost 2 decades now. And he lectures in media law, access to information law, privacy law at the University of Wits, where he is an adjunct professor. And Milo is the Dario Milo is the author of Defamation and Freedom of Speech, which was also published by Oxford University Press some years back. And he has written the Practical Guide to Media Law, which was published by LexisNexis. Another great lawyer, and he is also a member of the high-level panel of legal experts on media freedom. And he's acted in many cases, including a defamation case brought by Jacob Zuma, who was president, of course, at the famous over a famous cartoon by Zapiro, which Jacob Zuma didn't like, but justice came well out of it in the end. So welcome to you, Dario. And Alice Gardel. And Alice is along there. She is a human rights lawyer. She's chief of staff to Amal. She has spent her career defending and amplifying the voices of journalists, victims of human rights abuses, asylum seekers, incarcerated individuals, and by God, do we need her now. And she has worked at Reprieve, and there she specialised in arbitrary and unlawful detention. She's practiced as a public defender representing Aboriginal Australians in the Northern Territories and as a refugee lawyer in Australia and Greece. And Ms. Gardel also sits on the board of the Refugee Advice and Casework Service. And she is a great lawyer, a graduate of University of Sydney, Master of Laws and Fulbright Scholar at Columbia University. Welcome to you too, Alice. So an amazing panel of people. And so I'm going to kick off by inviting Lord Neuberger to introduce this special occasion.
Good evening. Thank you very much for coming to the launch of freedom of speech in international law. I'd just like to say a few words before you hear from the panel chaired by Helena. This is the first book with my name on the cover. So at the age of 76, I'm leaping a new hurdle. And my first book...
It's never too late.
Thank you. And my first book is on this topic because freedom of speech, and more particularly freedom of the press, seems to be under threat across the world to an increasingly worrying extent. Now, after an introduction, the book focuses on 5 areas which do justify a degree of control on free speech, but which are increasingly invoked to justify unacceptable restrictions on free speech. Those areas are insulting speech, hate speech, false speech, speech relating to espionage and official secrets, and speech relating to terrorism and public order. Each area is routinely and inappropriately invoked by unscrupulous regimes to undermine freedom of expression generally, and in particular, that most precious aspect, freedom of political expression. The chilling decline of this foundational freedom was what I think impelled Amal Clooney and me to try and set out in one book what international courts across the world have to say about freedom of expression, and to make recommendations about how the right should be interpreted and updated where there are gaps, inconsistencies, or anachronisms. And the standards set by international courts will influence domestic law, often directly and immediately, as we in the UK have discovered since the introduction of the Human Rights Act nearly a quarter of a century ago. The gratifying endorsements which the book has received from acknowledged and respected experts in the field, many of whom are here today, have encouraged us to hope that this text will play a role in the battle to preserve fundamental rights and freedoms and improve them through the law. Before I finish, I want to thank some of the many who've made this book possible. Amal Clooney is not only my co-editor and author or co-author of half the chapters, she's been the moving spirit behind this book and has driven it forward with her characteristic enthusiasm, expertise, perseverance, and quite often tact. Alice Gardol has been as indefatigable as she has been effective, not only as the co-author of several chapters, but also as our assistant editor, checking not only every sentence, but also every quote and every footnote. Thank you also to our talented authors, Philippa, Webb and Dario Milo, who we will hear from on the panel, as you've heard already from Elena, and Marko Milanovic and Rosana Garciandia, who are here with us tonight. And thanks, of course, to Helena herself, who supported this project from its early days and will be moderating our discussion, as you've heard. We're also grateful for the assistance provided by legal experts who gave us very valuable feedback, suggestions, and often corrections on the draft, including Professor, now Judge Sarah Cleveland, Judge Robert Sack, Judge Françoise Talkens, and Sir Michael Tugendhat. Thanks are also due to the faculty and students who provided excellent research support at Columbia University, here at King's College London, National Law University Delhi, Ghent University, Universidad de los Andes, and the University of Toronto, Pretoria Law School, and Sciences Po Law School Clinic. And thanks as well to the IBA Human Rights Institute, the high-level panel on legal experts on media freedom, and the many members of whom have contributed, and UNESCO, particularly the Global Media Defence Fund, for their support. Finally, thanks are also due, of course, to our publisher, the Oxford University Press, and to our hosts this evening, King's College London. Back to you, Helena.
Thank you so much, David. And David, it's always a great pleasure having you here, and your chairmanship of the high-level legal panel has been wonderful, and your book, along with Amal, you've produced something really extraordinary. Now, I'm going to ask you, Amal, perhaps to open up the discussion of the content of the book.
Yes.
You're going to come next? You're going to go up to the podium? Good.
Welcome to the launch of Free Speech in International Law. I'm delighted to be finally at this moment. It's taken a while. This is the second book that I have co-authored. The first being The Right to a Fair Trial in International Law with Philippa. And I can categorically say this represents my full library of academic textbooks in my lifetime. But I am more convinced than ever of the importance of the subjects of these.
Amal, could you for a minute pause? I think the sound is not great, and I see nods from the audience. I wonder if there's something that can be done with the technology to improve the sound. Is that better?
Could she be given that microphone? Could you take that microphone?
Is it possible to move that microphone?
Oh, is that?
No.
Oh, okay.
Is that better? Great.
Okay, well, I was just rambling on about how happy I am that the book is published, so I won't make you go over that again. But so these twin rights, the right to a fair trial and to free speech, are really the cornerstone of any free society, as we all know. Today, we rely on journalists to be our independent eyes and ears as a war continues to rage in Gaza. We relied on the press during the COVID pandemic to keep us alive. And in 2024, the media will report on voting during the biggest election year in our history, when more than 70 countries, housing more than half of the world's population, will go to the polls. But, as we all know, journalists are facing unprecedented threats. The first month of the war in Gaza was the deadliest on record, and over 70 Palestinian journalists have been killed so far. Journalists are being imprisoned at the highest rates since records began. Officials and oligarchs are weaponizing the law by filing baseless lawsuits against journalists, making free speech incredibly expensive. In too many autocracies, you can now count on one hand the independent outlets that dare to speak out. And even in democracies, free speech is on the line, with seminal US Supreme Court decisions like New York Times versus Sullivan that were decided decades ago unanimously, now being challenged by conservative justices on the court. We wrote this book not out of despair, although we could have, but out of hope that codifying the rights protected in international law can help those who are being targeted by rogue regimes or overzealous prosecutors. More than 170 governments have ratified treaties that define the right to free speech. And there are international courts that lawyers can petition if a person's rights are trampled. But for these protections to be real, the rights themselves must be clear. Codifying free speech protections was, however, a complicated task because at the international level, as many of you will know, there are 3 separate treaties that define the scope of the right: the International Covenant on Civil and Political Rights, the Convention on the Elimination of Racial Discrimination, and also the Genocide Convention. On top of this are regional human rights treaties covering Europe, Africa, and the Americas that define the right and its exceptions and limits. Many states are subject to multiple treaties and enforcement jurisdictions, so we had to survey all of that jurisprudence and see how it applied. And we conclude that the right to freedom of speech has achieved the status of customary international law. But as a lawyer who defends persecuted journalists, I realized that there was no single text that explained this corpus of international law and assessed states' compliance with it. This book intends to fill that gap for 4 core types of speech: political speech, false speech or fake news, hate speech, and speech affecting national security. And we make recommendations about how international law, which was developed in the aftermath of the Second World War, needs to be updated. I'm really pleased to report that the recommendations set out at the end of each chapter of the book have been endorsed by the United Nations Special Rapporteur on Freedom of Expression, by the International Bar Association's Human Rights Institute, the Committee to Protect Journalists, Reporters Without Borders, the high-level panel of experts on media freedom established by the governments of the United Kingdom and Canada, as well as experts and judges from across the world, many of whom are here. And thank you all for taking the time to read this and endorse what we recommend. So we hope the book will provide a roadmap for states and also for tech companies, and you'll hear more about that later, that are seeking to regulate speech or saying they're regulating speech in compliance with international law. As we have limited time, I'm just going to highlight a few of the places where our research revealed a significant discrepancy between what international law says and state practice, focusing on the issue of the criminalization of speech. First, we conclude that although international human rights bodies have found that imprisonment is never an appropriate penalty for libel or insults, more than 160 countries have criminal laws that apply to such speech, including criminal defamation laws, libel laws, so-called lèse-majesté laws, sedition laws, and treason laws. That means that instead of providing extra protection for political speech, as international law requires, these laws, in fact, impose the harshest possible penalty for it. One example is that of my client, Maria Ressa, a former CNN bureau chief in Asia, who faces over 6 years in prison if the Supreme Court of the Philippines affirms her conviction for libel following an article on her news site that discussed corruption allegations against the country's chief justice. Thailand has charged hundreds of people with the crime of insulting the king, and thousands of people in Turkey and India have been charged with sedition or similar crimes after criticizing those in charge. This, we say, has to change, and all international bodies should make clear that criminal penalties of any kind are never appropriate for defamatory or insulting speech. Second, we argue that under international law, no one should be imprisoned for simply spreading so-called fake news. Our false news chapter finds that to be criminal, such speech should be knowingly false, and it must be probable that it will directly or imminently incite violence, a serious criminal offense, or other prohibited harm. Yet every state's fake news law that we reviewed was criminal, and many of these were sweeping in reach and used to clamp down on insults to state institutions. Third, we found that state practice is strikingly at odds with international standards relating to speech affecting national security. International standards provide that individuals shouldn't be imprisoned for publishing information that may impact national security without giving them an opportunity to show that their disclosures were in the public interest. Yet our review of states' laws and practice revealed that a large number of states, including democracies like the UK and the US, do not recognize public interest as a defense or even a factor that courts can take into account in such cases, even though long prison sentences usually apply. And many states criminalize those who glorify or apologize for terrorism in very broad terms that don't require proof of intent, harm, or any causal link to a terrorist act. Our recommendation is that the public interest should be taken into account in national security cases, and that even though the European Court has actually approved crimes like glorification and apology, they should be repealed or reformed in line with broader international standards. Finally, we found that states were over-criminalizing hate speech through crimes like denialism and blasphemy, without requiring a showing of criminal intent to incite violence or serious criminal acts. Unlike other international bodies, the European Court has approved imprisonment for such crimes, allowing, in effect, governments and courts to penalize speakers based on the content of their speech, or on the basis of vague and subjective harms like intolerance. So we recommend that the 95 countries, including Western democracies, that currently criminalize blasphemy should repeal these laws. And we recommend the repeal of denial laws, which prohibit the denial of certain crimes, though these have also been tolerated by the European Court. And just as an example, I, some years ago now, represented Armenia at the European Court. And in that case, I argued that a genocide of the Armenians had occurred, but that a Turkish academic had every right to publicly deny it. The court actually agreed in that case, but it has found differently in cases involving other genocides, which of course begs the question, which are the genocides that you can't deny? And how does the court decide when debates are still ongoing, something that we're obviously seeing happening now? The better view, we say, is that opinions should be protected speech. Before I close, there are just a few people I need to thank as well. Our excellent team of researchers who I see over here somewhere, Alicia, Matthew, Emma DiNapoli, Katerina Lewis, Hannah Reid, who's come all the way from New Zealand, I believe, and especially Perry Lyons, Nadine Reiner, and Patricia Pena-Drillon, who have worked so hard to verify the factual and legal references throughout the text. Thank you. My warm thanks to Gail Gove, who I think is listening from New York, who asked very tough questions throughout the process. Thank you to our assistant editor, Alice Gardol. This book would not exist without her talent and her dedication and her ability to galvanize an army of allies along the way. And to David, a huge thank you to you, of course. As anyone who's here from the UK knows, David has long been one of the most respected lawyers in this country. But as he told me when I proposed this text, he had managed to avoid writing a book for 5 decades of a career at the bar, and I have to thank him for taking this leap, for his trust, for his good humor, for his extremely probing questions every time he reviewed drafts, and I know that the text is far, far richer as a result of the debates that ensued. And finally, to all of you, thank you so much for coming here, and for those who've joined online, hopefully they're still with us. This is not a light text or an easy conversation, but I am really heartened to see so many people interested in this issue. I was reflecting recently that I started practicing law more than 20 years ago now, and I have never been so sure of the importance of international law and its fragility. When I started my career In The Hague, I was working on the Milosevic trial, and I thought that this case, this moment represented a new era, an era of accountability. And since then, I found myself announcing that we're in an era of, or an age of impunity, and then an age of apathy. I would say we are in an age of cynicism, and I hope that it won't soon become what has been called an age of unreason. But I believe that if people are committed to an international system based on the rule of law, the tide can turn, and that if we remain vigilant about our most basic human rights, things can improve. We hope that our book can make a contribution by helping all of those in classrooms and courtrooms around the world who are determined to play their part in protecting human rights. Thank you.
Amal, I think it's so important to remind us all about the importance of really retaining some hope that law can make a difference. And we are seeing, I really agree with you that we've gone through those stages of seeing, well, first of all, an indulgence and an impunity for wrongdoing, and then apathy, but cynicism that law could ever effectively deal with anything. And it is important that we actually reinvigorate the debate about why law matters. And it's wonderful to hear how you describe the importance of that. I'm now going to ask you, Philippa, if you don't mind, going up there and speaking about political speech.
Good evening. In my remarks, I will focus on the recommendations in the chapter I co-authored with Dario Milo and Rosana Garciandia on insulting speech, speech that is said to harm the reputation, honour or dignity of the subject, with a focus on speech about political or other leaders. I will also briefly refer to the chapter on false speech that I wrote with Marko Milanovic. International human rights bodies agree that public figures, including those holding the highest office, are legitimately subject to criticism and political opposition. This is fundamental to a democratic society. But instead of providing extra protection for political speech, we found that many jurisdictions impose extra punishment for the criticism of the state and its officials. Our survey of state practice revealed what you have to do if you ever choose to be a thin-skinned leader seeking to silence dissent. First, you have to pass a vaguely worded law, making it difficult to know what speech is covered. You could take inspiration from the Turkish crime of speech that degrades the nation, or India's criminalization of speech that excites disaffection towards the government, or Myanmar's prohibition on speech that damages tranquility. You should impose a long limitation period so the possibility of prosecution or litigation lingers for many years. Don't include an intent requirement or make it very ambiguous. Do not require the showing of actual or potential harm to establish that speech is insulting. Provide that each publication of a statement, every sharing of a post, every retweet gives rise to a separate cause of action. Don't provide for a defense of truth or make it conditional on being justified, as in Sweden. Don't provide for or provide watered-down versions of the defenses of public interest, reasonable publication, fair and accurate reporting, and opinion. Impose criminal penalties. Take a leaf from Thailand's playbook with 15-year prison terms, or follow Russia's example of fining a person 3 years of their salary. Impose extremely high civil penalties, tens of millions as in Ecuador, or billions as in the US, to achieve a chilling effect. And you might also restrict civil liberties by prohibiting the holding of public office, or working as a journalist, or banning travel. To be clear, this is not what the book recommends, but our survey of global state practice found that these practices are surprisingly and disturbingly prevalent. Drawing on the standards established by international human rights bodies and using best practices in domestic jurisdictions to fill in any gaps, we make 15 recommendations for protecting political speech. Amal has already noted our headline recommendation. States should decriminalize laws on insulting speech. Imprisonment is never an appropriate penalty. Criminal penalties should be a last resort for false speech. The primary remedy for such speech is more truthful speech. And I will just highlight 3 other recommendations. Public interest speech should receive greater protection from defamation liability than other speech. International human rights law upholds the importance of public interest, but more clarity is needed on its role. It's sometimes treated as a factor governing the permissibility of speech, an element of a defense, a standalone defense, or a justification for a more onerous intent requirement. Public interest speech should also be broadly defined. It goes beyond, but also includes political speech, but it is not as broad as everything the public is interested in. Plaintiffs suing on matters of public interest should bear the burden of showing that the allegations are false and that the speaker was at fault. This is done in the US and Honduras. States should consider requiring that a plaintiff prove a higher degree of fault on the part of the speaker for public interest speech. And our second recommendation is that in that regard, states should adopt an objective standard of fault, at least to a negligence standard in laws that impose civil remedies for defamatory, insulting, or seditious speech, and at least to a gross negligence standard for speech relating to the public interest. Some states have laws that punish the speaker regardless of fault. And at the other end of the spectrum, the US has the actual malice rule for claims brought by public officials and figures. The plaintiff must show that the speaker acted with knowledge of the falsity or with reckless disregard. This is subjective and often very difficult to prove. The standard has been recommended for public interest speech by the UN Human Rights Committee, but there are also other ways of providing a protective threshold, such as an objective standard of gross negligence. And for false speech, we recommend that misinformation offences should have a high mens rea requirement as regards the falsity of the statement and the harm caused by it. The reality is that while misinformation often originates from people acting knowingly or with an intent to cause harm, it is often spread by people who subjectively believe it to be true and don't intend to cause harm. And imposing liability on the second group is likely to have a chilling effect on free speech. Our third recommendation is that only statements that are likely to or have caused direct, immediate, and serious harm to reputation should be capable of giving rise to liability. A serious harm requirement is endorsed by the UN Human Rights Committee, the European Court, and inter-American bodies, as well as UK and Australian laws. Similarly, for false speech, states should not penalise misinformation unless it is objectively likely to cause serious and direct or imminent harm. We recommend that states may impose criminal penalties for false speech if it incites violence or a serious criminal offence, endangers human life or seriously harms health, or seriously harms the integrity of elections. I conclude with congratulations and thanks to Amal and David for their leadership on this project and for their example as lawyers waging justice. When Holger Hestermeyer and I founded our new centre, SIGAD, we hoped that it would become a site for research exactly like this, rigorous and impactful. Thank you to our centres and events teams, to Natalia and Ludovica, and my last thanks goes to our brilliant King's students, many of whom are here tonight or online, and who are also pursuing careers in international law, for their contribution to the book through the Media Freedom Seminar. Thank you.
And foremost, pay tribute to the superhuman efforts of David, Amal, and the rest of the team in ensuring that this important and seminal contribution to free speech jurisprudence is published. I also would like to acknowledge the contributions of my co-authors, Pip and Rosana, in the chapter I assisted with, Insulting Speech. And I want to speak today principally about one of our recommendations in that chapter. This is the recommendation that states should enact anti-slap legislation, that is, legislation that seeks to counter strategic litigation against public participation, lawfare, which aims to silence speech on matters of public interest. As you'll know, the targets of slaps are often journalists, activists, human rights defenders, lawyers, whistleblowers, NGOs, I dare say some of you in this room. Happily, there is momentum in the European Union, the Council of Europe, the UK, and some other countries to enact exactly the kind of legislation we recommend. And even in the US, where the term slap originated in the late 80s, and where legislation has existed in some states for some time, there is a drive to enact a federal law regulating slaps, and for more states to pass anti-slap laws. Europe was galvanized to act by a great media freedom and personal tragedy. On 16 October 2017, Daphne Galizia, Malta's top investigative journalist, was assassinated when a car bomb planted under her seat, her car seat, exploded. Her work focused on corruption and organized crime, and she was facing over 40 civil defamation lawsuits and 5 criminal defamation cases at the time of her death, and they survived her death. Most of these were brought by Maltese government officials and businessmen. This murder of a truth teller, all too common in many countries around the world as we see today, finally triggered action by the European Union to act against slaps. It's indeed appropriate that the draft European directive to regulate cross-border slaps is dubbed Daphne's Law, and the European Council and Parliament reached agreement just over a month ago on the wording, so change is on the horizon. For the United Kingdom, the invasion of the Ukraine by Russia brought into sharp focus, for the government at least, the ugly truth that many Russian oligarchs weaponize English defamation law here to threaten, bully, and intimidate their critics. London is, after all, still the libel capital of the world. And as Jeffrey Robertson has written recently, and Amal referred to this earlier, we do not have free speech in Britain, we have expensive speech. The UK government's attention to slaps is thus welcome, albeit currently through what I regard as the insufficient and inadequate mechanism of the Economic Crime and Corporate Transparency Act. As we discuss in our chapter, regional courts are also weighing in against slaps. For the first time, the Inter-American Court of Human Rights in 2021 and the European Court of Human Rights a year later used slap terminology to describe the lawsuits in those cases, which were a criminal case brought by the former president of Ecuador against a journalist and a civil defamation claim by a Russian organ of state against an online media company. Some domestic courts are also receptive to these anti-slap arguments, and I'll be forgiven, I hope, for praising my own country, South Africa, where apart from our parliament decriminalizing defamation just last year, late last year, in fact in December, we have for now, for the first time, sought to regulate slaps through the common law. And that happened just over a year ago in a case where a multinational Australian mining corporation sued environmental activists who criticized its mining activities. And the South African Constitutional Court affirmed a common law slap defense as a species of abuse of process. The Northern Ireland High Court effectively did the same about a week ago. Yet these common law victories on slaps are no substitute for a comprehensive anti-slap statute, as we recommend in the book. There are some important ingredients of such laws that are shared in many of the countries who have them or who are about to get them to ensure their efficacy. First, it's essential to allow an early dismissal procedure, empowering a court to dismiss a case as a slap without the need for the case to go to a full trial or oral evidence, where the emotional and financial costs are particularly draining and daunting. Second, the onus should be on the plaintiff to show they are likely to succeed at trial, not on the defendant to show the opposite. And thirdly, full costs should be awarded to the defendant if they succeed in dismissing the case as a slap. As we argue in the book, this type of legislation is required to ensure that the dissemination of public interest speech is not chilled, that those speaking truth to power are not silenced. It should not, in my view, require the assassination of an investigative journalist or a Russian invasion to provide the motivation for slap legislation. Thank you.
Thank you very much indeed. It is one of the great challenges now, that whole issue of crushing people through the law. Alice Gargo, and perhaps you would like to talk about some of the recommendations in relation to what we do about social media and
Thank you, Elena. Good evening, everyone. Tonight, I would like to tackle some of the challenges that arise when seeking to apply international human rights principles to speech online and to the global tech companies that control it. In writing this book, we traverse all types of speech, but online speech presents a particularly important human rights challenge, not just because of the rate at which the digital world is evolving and growing. It's because the right to freedom of expression is enshrined in treaties that were drafted decades ago, before the internet, social media, AI. And of course, these treaties were drafted to bind states, not private actors. And while states do have a role to play in regulating speech online, it is private actors who hold immense power in our increasingly online world, and who have failed to limit the incredible spread of dangerous speech online. I'll give you one chilling example among many, being the genocide in Myanmar, where a damning UN report was released describing the link between hate speech on Facebook and real-world violence. The report saw Facebook scramble. Minutes later, they removed 70 pages and accounts associated with the Myanmar military, and ultimately conceded that they weren't doing enough to prevent the incitement to violence. So, social media companies are not ignorant of human rights law or beyond its reach. And it is in fact the companies themselves who have uniformly countered this argument. All of the social media giants, even present-day Twitter, now X, have policies which recognise their commitment to upholding free speech as it is defined in international human rights law, including treaties regulating freedom of expression and the UN guiding principles on business and human rights. But challenges in applying these laws endure. And tonight I would like to discuss three of them. Three challenges that need to be considered by social media companies, by those seeking to support them to be human rights compliant, and also those seeking to hold them to account. The first challenge is divergences in existing jurisprudence. As we write in the book, much of international free speech jurisprudence is consistent and mutually reinforcing. But there are key points of disagreement. When the European Court in particular has been more accepting of restrictions to speech. Now, Amal has already touched on some of these examples. They include blasphemy and denialism of historical facts. But how should a global company respond to these? Particularly when, in the case of X, for example, they explicitly state that they're guided both by the European Convention on Human Rights, but also US First Amendment jurisprudence. Well, addressing this challenge is part of the reason that we've written this book, to provide clarity, but also to recommend consistent best practices when these divergences exist. A second key challenge is the question of who. Who should be determining what speech is regulated online? This question arises as automated content moderation contributes more and more to what we see and we don't see online. YouTube recently said that AI detected 93% of the videos that were ultimately taken down, and Meta's figure is also above 90%. But we've also seen how poorly suited automated content moderation is to picking up cultural nuances and therefore differentiating between peaceful and violent expression. A few examples: Meta was criticised recently for removing posts that called for death to Ayatollah Khamenei, on the basis it should have recognised these as political rhetoric in the context of a repressed nation. And Human Rights Watch has recently reported multiple instances in which clothed images of dead children in Gaza were flagged and removed by Meta's nudity policies, and has recently documented over 1,000 instances of what Human Rights Watch considers to be peaceful content in support of Palestine to have been restricted by Meta. Social media companies have sought to add in layers of human review and appeal mechanisms. But the question still remains, what is the best system for this? One model is Meta's oversight board, through which Meta outsources key decisions to a group of independent experts. There are some downsides to this approach, of course. The board only has the capacity to consider a small number of emblematic cases and can be hampered by how cooperative Meta will be. But Meta to date has shown significant compliance with board decisions. And the board is a positive step in comparison to, say, backsliding at Twitter, which now X, which dissolved its human rights advisory body, the Trust and Safety Council, and then fired Twitter's entire human rights department. An alternative model is the Christchurch Call, an initiative established after the brutal 2019 terror attack, which was live streamed on Facebook and within 24 hours had gone viral. At one stage, YouTube was removing a copy per second of the attack. The call is made up of both states and tech companies, whose collective action has in fact proven to effectively reduce terror content online. For example, its crisis response protocol meant that a live stream of a shooting in Buffalo in 2022 was taken down within 2 minutes, rather than the 29 minutes it took to take down the Christchurch attack. The recent rush to regulate AI is presenting us with the same set of challenges. And indeed, maybe the private-public Christchurch Call model could be a blueprint for this new and critical phase of tech regulation. And the final question that I want to raise that arises in the context of online speech is, what should states do when social media companies get it wrong? A theme that arose across the book is that, despite how abhorrent and offensive certain speech may be, heavy penalties for speech can be a blunt instrument that incentivizes over-censorship. Take, for example, Germany's Network Enforcement Act, which compels social media platforms to remove certain unlawful content within 24 hours or face €50 million fines if they get it wrong. Mechanisms like this encourage social media companies to clamp down on too much speech just to avoid these heavy fines. And more than a dozen states, including Turkey and Russia, have since been emboldened to follow suit and pass similar legislation as a way to suppress dissent online. To conclude, these three challenges will only deepen as democracy and online free speech are threatened like never before. And while there is no silver bullet, we have written this book because we believe that international human rights law, despite divergences and complexities in enforcement, is the fundamental standard to which social media companies must be held to. Thank you.
There are a number of people I really would like to invite to contribute to the discussion, because I know that they have great expertise. So let me start, but let me say that time is of the essence, and I'm afraid we're running out of it. And only a couple of minutes, I'm afraid, and I'm a fierce invigilator of the time. So I'm going to go first of all Jodie's there. Jodie Ginsberg. She is the Chief Executive of the Committee to Protect Journalists, and I know that she is a great expert in this field, and I'd love to come in from the United States. Jodie. Over to Jodie Ginsberg, please.
Thank you so much, Helena. As of December the 1st, 2023, 320 journalists were in jail worldwide. That's the second highest number since we started keeping these records more than 3 decades ago. A majority of the journalists in our census reported on politics or human rights. More than 65% of those jailed faced anti-state charges such as terrorism or false news. In addition to arrest, we see the removal of licenses, freezing of funds, and shuttering of professional organisations that support journalists. An increasing number of journalists that were on our prison census are held without charge, as we see currently in the administrative detentions by Israel of Palestinian journalists in the West Bank, or they're held by governments in detention long after their sentences. As we enter this banner year for elections, free expression and a free press will be more important than ever. And we at CPJ know it will be under threat like never before. And I personally know, having read the book and had the pleasure of being able to endorse it, that I will be wielding this book to ensure that we can protect journalists in this year, but in years to come. And so thank you so much. I know it will be of great use to us in our work, and hopefully to all of those seeking to support journalists and a free press worldwide.
Julie, thank you. You do incredible work, and it's just great to see you up there in front of us. And I'm now going to move to Baroness Françoise Julkens, who is a judge on the European Court of Human Rights, and who has been a member of the high-level legal panel. She's a great friend. Françoise, it's lovely to see you there.
Okay, can you see me? Thank you very much, Elena. Thank you for inviting me in this, because I think it's so important. And you are right, this book is really, truly an extraordinary book in every sense of the word. And I like to say why, and I have 5 good reasons for that. First reason, Amal, I really like what you said at the beginning of the book. And without freedom of speech, all human rights are under the threat. And then you quote Milton, and Milton put it, and I found that so nice: give me the liberty to know, to utter, and to argue freely, according to conscience, above all liberties. And I will continue on the same line with the European Convention of Human Rights. Remember the first case, Undecide versus United Kingdom, December 1976. Freedom of expression constitutes one of the essential foundation of democratic society. And that's for me the point, the most important point. You quote Milton, and I will quote Paul Ricoeur, a French philosopher, and he said that only a society which admits division without itself is democracy. And that's freedom of expression. That's exactly freedom of expression. Freedom of expression is not only a subjective right against the state, it's an objective fundamental right to life in a democracy. It's not an end in itself. It's a means for establishment of a democratic society. And today we know where to fight for democracy. Democracy is at risk, democracy is backsliding, so we have to fight it. Second, there is no hierarchy within human rights, but I really think that freedom of expression is a proeminent right, which is for me quite important. Second point, you are right. Now, of course, basic freedom of expression has an unprecedented attacks. And of course, there are some limitations to freedom of expression, but limitations should be strictly construed. And today the principle is reversed. And what we are saying today is that journalists, media professionals are in danger, and their protection must be ensured. And I want to pay tribute to them tonight. I think it's so important what we have heard now. Their life is at stake. Their life is in danger. Just to express freedom of speech, just to accomplish their work for us, for democratic society. So I think for me it's so important. And I was really moved by what I heard a few minutes ago by the other people who intervened. A speech in book is one thing, but the reality of violence is another thing. And that's how I like the spirit of this book, because all the time you try to go in the reality. Law in book, law in action. And I think both are quite important. Third reason, I've never seen such a comprehensive book covering all international standards of freedom of expression, treaty, customary law, jurisprudence, all over the world. And all over the world, for me, is so important. Middle East, Africa, Asian Pacific, Europe, North and South America. So we can see how this provision of freedom of expression could be analyzed, could be interpreted, could be seen, could be accepted in different ways all over the world. And this dimension for me is very important. Fourth reason to really like this book. The particular subjects you selected are exactly those who are today sensitive and difficult. Insulting speech, hate speech, false speech, espionage, terrorism law. So with all this question, and we are, of course, this question you should give an answer. And so your book now, covering international standards all over the world on this specific topic, for me it's really I should say a Bible, but it's really for me a book now which is becoming for me absolutely indispensable. I have to use it all the time because there are so many problems which we are to solve. And then my 5th reason, and I have already said that before, I really like that you add recommendation. I think that's very courageous to add recommendation. How international law related to freedom of expression should be interpreted, applied, and reformed. Academic work, scientific research are at the service of society. That's for me, it's absolutely evident, it's absolutely obvious. Academic work and scientific research are at the service of society. So these recommendations are essential for law in action. Amal, I am a little bit, I understand your conclusion, saying that now international law is in the age of cynicism and impunity. Maybe, when you said that, I think maybe you're right. But I really think that together, in solidarity with all these people who are suffering now for freedom of expression, we have to fight. We have to fight because we need international law. We need law today. We need the whole rule of law. Otherwise, it's the situation of violence, and then we cannot accept anymore. So really, thank you for this book, and I'm a little bit sad not to be able to be with you there at King's College. So congratulations in person. Thank you for your book. Thank you for your commitment. Thank you for what you have said, and thank you for the future.
Endorsement of this piece of really important work and recommendations. And it's just great to see you again. I'm now going to, one of our great judges, Sir Michael Tugendhat, is here in the room. Michael, I wonder if, is there a microphone that could come? Thank you very much. I've got to explain to all of you, so Michael Tugendhat is one of our, he's basically the leading judge on media law, and it's wonderful to have you here. And you gave such a great endorsement to the book, saying that it was a highly original, critical approach, and that you said it was unique and an invaluable resource, and you paid tribute to the distinction of the scholarship and the command of the issues by the authors. So I want to thank you for being here tonight and for your help with the book and your recommendation of it. So,
well, I'd like to thank you for giving me this opportunity of extending my enormous congratulations to everybody involved, Amal, David, everybody who contributed, and the very large number of people whose names appear in the acknowledgements and elsewhere. It is an extraordinary achievement, as anyone who's had anything to do with writing a law book will know exactly how much work and skill has gone into this. It's been, in the last 40 years, English media lawyers have been reinterpreting English common law to conform to international standards. Is it prescribed by law? Is it for a legitimate aim? Is it necessary and proportionate? We've come a long way, and so far have we come that many people take the view that Strasbourg has spoken and the case is closed. Well, this book will reopen it, because half the cases in the book do not come from Strasbourg, and there are divergences. There is much to do to resolve these divergences, and this book provides an indispensable and unique way of doing that. It's very difficult for judges and counsel to get information about foreign and international law, and this is marvelous. And I do particularly welcome the emphasis that's been placed on the application of international law to private actors. It's true the treaties are not made with private actors, but human rights are not confined to treaties. This is a very important point to stress, particularly in the light of the huge influence of the tech companies. Thank you again for giving me this opportunity, and very, very many thanks and congratulations to everyone concerned.
He's from Reporters Without Borders, and he's had a chance of reading the book in advance too. How did it stack up, Antoine?
A few weekends actually, and a real pleasure and a learning. I'm still learning. Actually, I told you and David and Amal, and really thank you very much, very much. We at RSF, we've been 3 of us actually reading the book. The key question was, would RSF be accept to endorse the recommendations? And you know, Reporters Without Borders is an international organization. Our and my core experience comes from civil law, not from common law. And so we had a mixed team, but I had to do a deep dive into common law. and actually it's deep because it's heavy. Now look, what is very important for us and what we're thankful for is with the book, you give us keys to understand our times and us, but we know many others who should take the time to study it carefully, the book. A number of governments in particular, fighting terrorism, this very legitimate and necessary goal being distorted and instrumentalized, as we said, Amal, recently you referred to Palestinian journalists killed in Gaza. How can't we have in mind how law is being instrumentalized and distorted to justify such violation? We call it at RSF international crimes. We have filed a number of complaints with the ICC, actually, including on suspicion of intentional murder of Palestinian journalists in Gaza, including one with his press jacket killed by a sniper shooting, not in the bombing of his building. Everybody should read the section about this thematic, about espionage. How can't we think of, from Jimmy Lai, US journalist held in Russia, up to here, by the way, Julian Assange, and reading the chapter, dedicated chapter, of course, is a key for understanding false news or fake news. I think we have more than 80 countries with key elections, 4 billion people, citizens concerned. Fantastic chapters in the book. Not least, why you explain, how social media platforms, and I would add intelligent artificial generative AI platforms, should abide by law. Your last recommendation is to them. Commit to respecting principles and legal obligations. Maybe the next book, David, suggestion, could be about why and how this is what RSF supports. Put in place obligation to platforms to abide by. Thanks for having us in. Merci.
Marco Milanovic here. Marco, get the take the microphone. Marco was the co-author of the False Speech chapter, and he's a professor of public and international law at the University of Reading. And what did you think of the False Speech chapter?
Oh, I loved it. So I would add to what Philippa had said, I would add just maybe a couple of points that I think are important. The first is that when it comes to regulating false speech, really there's two kinds of states or two kinds of governments or regimes that I think the book speaks to. One is the kind of state that uses a fake news law to suppress political opponents. That's like Russia today, where there's a law that says that if you say something false about the Russian armed forces, you can go to prison for 15 years. So that's case number one. But then there are states like ours, still at least, where the government genuinely is committed to free speech, but some kinds of speech, like false speech, can cause real harms. And we saw that in the context of the pandemic in particular, how false speech on questions of COVID, vaccines, medicine, so on, really caused tremendous harm. And there really is a serious question about how to regulate this. Now, we in the book focus mainly on criminal law. And here, as Philippa rightly said, we want high thresholds of causation and intention to justify criminal punishment. And we think it can be justified in exceptional circumstances. If you falsely say and know that it's false, that this is, eating garlic is a cure for COVID and people die, we can put you in prison, yeah? But there's a whole universe of regulation beyond criminal law, and in the book we don't necessarily deal with that as much. And there I think we need to be a bit more open to some kind of regulatory intervention. So for example, when a social media company removes or labels false statements, I think they can do it at a lower threshold of justification than criminal punishment, yeah? Negligently false statements can be removed if they harm public health, for example, and I think that can be justified. Or if one teaches in this university and teaches students there's no Holocaust, there's no evolution, or the earth is flat, the professor can be fired even if they cannot be imprisoned. So that would sort of be the core message I would want to add on the false speech chapter. Thank you, Helena.
Thank you so much. Marco, thank you for your contribution. And Rosana Garciandia, who is and I should tell you about Rosana because she's the co-author of the defamation chapter. She actually is a lecturer here at King's College in International Law, and it's great to see you, Rosana. Perhaps you would like to tell us about your insulting speech chapter.
Thank you very much, Madam Chair, and thanks also to the panel for their insightful remarks on a right that clearly remains under threat in 2024, so there's a lot of work that is still to be done. The Chair suggested previously to me that I could make some remarks on some trends, perhaps, in Latin America as one of the regions that we were looking closely to. And one of the aspects that the chapter I had the pleasure to co-author with Dario and Philippa emphasizes something that Dario was referring to, and is actually one of the most interesting trends that we saw in Latin America, and that's how SLAP has been identified by the Inter-American Court as a threat to freedom of expression. And I think it's never enough emphasizing that. It's so important because we are talking about journalists. We had very important people talking about journalists who know their work very well and their threats very well here today. Journalists, bloggers, activists, academics who are under threat and who have been silenced through lengthy and costly proceedings. And our recommendation in that regard that Dario was referring to, I think it's important to remark. I guess Amal was referring to hope at the beginning of her speech as one of the engines of this work. And I guess that's also what leads me to identify another trend in Latin America, where some countries have already started decriminalizing this kind of of defamation laws, limiting enforcement of defamation laws. Jamaica was one of the first in doing that. Uruguay, Guatemala have also been examples. Honduras removed criminal sanctions for desacato recently. I guess it's a positive note on which to finish, although obviously there is a lot that needs to be done. Finally, a big thank you to the King students involved in underlying research on this project. It was inspiring and encouraging to work closely with these brilliant future lawyers. Many of them are here with us today, so it's very nice to welcome them back. Identifying state practices and trends in jurisprudence was very important to shape these recommendations, and you are a big part of that. And also, I would like to thank the editors for encouraging students' involvement in this very important project, and the high-level panel for engaging with our students in that very important process. Congratulations to all involved. This publication will be, as we've heard today, an invaluable contribution, an invaluable instrument to protect media freedom around the world. Thank you.
Way to take us to the ending of our meeting. And I'm going to pass over to Lord Neuberger to make some concluding remarks. And I too want to thank the students. It's wonderful, the contribution that has been made by new generations of lawyers. You're the people who are going to make the difference. So, Lord Neuberger.
We're running late, so I don't want to be too long. And just picking up one or two points, I suppose. First of all, the fundamental principle is the importance of identifying a really good reason for restricting freedom of speech. And secondly, if there is a reason, ensuring that whatever relief, to use a neutral word, one imposes is proportionate. As Mikhail Milanovic said, there are times when even criminal sanctions are appropriate, but it isn't a binary choice between doing nothing and criminal. There are middle ways with regulatory rules which can be applied. Secondly, I suppose one of the thoughts going through my mind today is that everyone, I imagine literally everyone in this room, is concerned with supporting freedom of speech, freedom of expression, press freedom, and is concerned about the way, looking across the world, that it is being impinged on and indeed abused. The main problem is to make it an important topic for a lot of people. In a way, the danger is we all talk to ourselves and to each other, and we're preaching to the converted, preaching to the choir. The danger is, or the difficulty is, to get the message across generally. And all one can do is, if you care about it, is to talk about it. What many people, including Amal and I, and all our co-authors and commentators on the book have done to try and draw attention to it. There's always only a few people who speak up for important issues, and in the end one hopes to get the message across. The danger, as Amal said in her talk, is we go from impunity to apathy to cynicism to despair. And generally speaking in the world, we may be getting close in some places to despair, but we mustn't let ourselves get there. We have to accept that you go through bad phases and one comes out of them. And meetings like today and contributions like today's are so important in helping achieve that. We've been told and reminded how important, by Philippa, how important public interest is. When you think about it, it's almost absurd that public interest doesn't always play a part in alleged breaches of rules seeking to restrict freedom of expression. The whole point of freedom of expression, like all such rights, is that it is in the public interest that we have it. So if there are circumstances in which it's said to be infringed because of insults or hate speech or even national security, it seems to me obvious that public interest should play a part. Sometimes it has to be accepted in terms of mitigation rather than actually excusing it, but it always ought to be there. We heard about slaps from Dario, and it's embarrassing for an ex-judge to think that courts, which we think of as supporting free speech, are actually being used to cut it down, to shut up free speech, often on important issues. And it's nice to think, or would be nice to think, that the judges could do more to ensure that the courts aren't being abused. I was reminded in my time as Master of the Rolls, we had problems with so-called super injunctions. That was injunctions which were so secret that we couldn't even say they'd been granted. The press and Parliament was naturally concerned about them, and we as judges did try to do something about them. In a system such as ours, where laws fundamentally get made by Parliament, it may be difficult for the courts to do that much about slaps. And it isn't for me to say that they're not doing enough, but anything the courts can do, anything that the legislators can do, and anything that lawyers can do should be aimed towards reducing, cutting down, and hopefully getting rid of slaps. So far as social media is concerned, much has been said about them, and clearly in the modern world we can't just be looking at states. In many ways, the largest social media companies have more power, particularly when it comes to messaging, than the great majority of states across the world. And we really do have to concentrate on them. They can be used for very malign purposes, and we have to accept that that is so, and we have to control that. But equally, because of their power, they have to be seen as akin to a state and treated as such in many ways. Very difficult to achieve. We were reminded by Jody Ginsberg that there were over 300 journalists across the world, a record number. And so far as that's concerned, it does emphasise the need for vigilance and action to be taken. And Michael Jugendat, my friend and former colleague, rightly reminds those in this country who have got very interested in the European Convention on Human Rights since it became part of our law, although I was going to say recently. For me it was recent, but for many people it's all part in the DNA. But it's not what the European Court says is not the be-all and end-all. And for my part, that was something I learnt really on contributing and writing this book with Amal and editing this book with Amal, that there are other views out there, and in many ways, for instance, an obvious topic that's been covered, Holocaust denial, the European Court on Human Rights is not exactly in the vanguard of freedom of speech. And we were also reminded by Antoine of the serious problems that can occur still in places where we would have hoped that freedom of speech and in freedom of journalists to report and even lives of journalists were safe, but are not. The price of vigilance, it's often been said, the price of liberty, it's often been said, is eternal vigilance. And if ever we needed eternal vigilance, it is now. And as I say, it's often a few voices crying in the wilderness, not many people interested, they want to put their heads down, get on with their lives, don't want to be under threat, and aren't concerned with human rights until it's too late. And our role is to try and wake them up and make them sure they care, make sure they care. And I hope that this evening's very good contributions from a number of people will achieve that. Thank you very much.